Welcome to the Roetzel Health Law Hotspot. Health Law Hotspot is a podcast for physicians and health professionals that covers the legal issues and trends that affect the healthcare industry.
Hi, everyone. Welcome to the Health Law Hotspot. This is Ericka Adler, shareholder and leader of the healthcare practice at Roetzel and Andrus. Today, I'm joined by my partner, Jonna Eimer, also a member of our healthcare practice, and we're going to be talking about operating agreements, what they are, why they're important for healthcare providers, and some of the most important provisions that we see people either not talking about or not including in their documents. So welcome, and Jonna, thanks for joining me today.
Thank you so much for having me. I'm happy to be here.
So why don't we start by you explaining what an operating agreement is and when and why any kind of healthcare practice is going to require one?
So an operating agreement is the governing document for the practice, for a limited liability company or professional limited liability company, which a lot of our healthcare practices are formed as. So it's the governing internal document that governs and determines how decisions are made within the practice, how profits are distributed, allocations of profits and losses, distributions, management, things that govern the day-to-day control and extraordinary events like material changes, whether there's a sale, whether there's a transfer of interest in the agreement. All these things are included in the operating agreement, or at least we recommend that they be included. And the real importance is by drafting it and taking care of these provisions and these decisions early on, the hope is when an issue comes up later in the practice, we have a document that we can readily refer to that will help guide us through that decision. And so the hope is that it doesn't become an issue for the practice that could lead to discord or disruption or partner animosity. So the idea is we have this governing document that we can look to and help us get through those difficult questions that may arise.
Okay, perfect. Now, some people may not be familiar with what an operating agreement is, so maybe we can also speak to the difference between what an operating agreement is and what a shareholder's agreement is, because people often get those confused.
Yeah, so an operating agreement is similar to like a partnership agreement. It's just the governing document we use for a limited liability company. And so it describes the ownership interest, the equity interest, which we would call shareholder or stock interest in a corporation, or partnership interest in a partnership. What I like to say is why we so often do LLC operating agreements is because they give you a lot of the flexibility you get with a partnership document, but the protections and limited liability you get from a corporate document and when you have shareholders. So I like to say it's a one-time, one-stop-fits-all kind of document that can govern a practice. And you also avoid a lot of the corporate formalities that you have in a shareholder agreement or in a corporate form where you have annual minutes and consents. Well, we can do this, and it's good, it's good to have those. It's not required. The annual minutes and annual consents, all those corporate formalities are not necessarily required in an operating agreement.
So I guess one of the things I always wonder, I know that banks very often require that you produce an operating agreement, even if there's only one member, but I don't see this required typically for a corporation. Has that been your experience as well?
That the banks don't require a corporate.
Yeah, so very often, like even if it's a single owner, banks will say, we won't open an account, we want to see an operating agreement. So we'll be preparing these single member operating agreements. But when it comes to a corporation, they don't require that. So I think that sometimes also creates confusion. I'm not sure the reason for this, but has that been your experience as well?
It has been, though sometimes banks will require the corporate, just different corporate documents, right? Your articles of organization, your good standing, your bylaws, they may want to see them. They don't seem as interested, though, always as they are in the operating agreement. And another question we get asked a lot is, well, do we even, if it's not for the bank, why do we need this if the bank isn't requiring it? And the answer is a lot of states don't require it. It says you may have an operating agreement, but you don't need one. With a single member entity, that might be the case. But once you get multiple members, managers, it becomes a lot more complicated. So we would recommend, even though it may not be required by your state, that you do draft one.
So that kind of leads me to my next question before we kind of dive into the details of the agreement. What happens if you just don't put anything together and don't sign anything, and there is a dispute down the road, where do we get answers from? Do we have to go in front of a judge and have a judge decide what is fair? Or, where do we look for answers, I guess?
Well, you may ultimately have to go before a judge to decide, but you default to the state law provisions. So for Illinois, that would be the Illinois Limited Liability Company Act, the Illinois Professional Limited Liability Company Act. So if you don't have a governing operating agreement, then your default for a dispute would be the state law provisions that govern your entity.
Okay. I think that's really important. A lot of times people put something together but never review it, never sign it, or they think they don't need one, or they write some points in an email and they never sign anything. And then when they get into a dispute, they think, well, we can do whatever we want. There's no guidance, but there actually is some guidance. And the first place as lawyers, you and I would look is, what does the statute say? But the other points we also look for is, how are they operating, right? And so I think that leads me to my next question is, let's talk about the process of creating an operating agreement. So everybody does it differently. One of the things that I like to do, and then you can tell us how you like to do it, is I don't like to just say, here's a great form, look it over, because something's worked in the past doesn't mean it's going to work again. And a lot of times when we're doing dental practices or medical practices, there's a lot of detail we want to include in there that's very specific to that practice. The way I like to do it, and you may do it differently, is to maybe either have a call where we run through a bunch of particular questions. Is everybody an equal owner? How will decisions be made? What are the competition rules, etc. Or send out like a little checklist with the idea that people can sit down and take the time to talk amongst themselves about what they want those answers to be. And then we can talk about where there is no agreement on those answers. And one of the reasons I like to do it this way is because usually when I'm doing an operating agreement, I'm doing it for the entity and all of its owners. I'm not doing it for any particular owner. So it always somewhat makes me uncomfortable if one person tells me what they want in the document and I go ahead and draft it like that, assuming that everybody else wanted the same thing. So that's how I like to do it, but I have seen it done so many different ways. How do you like to do it?
Yeah, I think I've seen your checklists and they're wonderful. They're really good. And I agree with you, when you're corporate counsel, they're a really good way to get the members and managers talking and discuss those considerations together. I usually start with a phone call, get kind of the basic ideas of what the business is, what their kind of general intent is, and then I follow up with a series of related questions. Because like you said, I think people like to think that we have this a form for every occasion that we could imagine in health law or other law, wherever we practice. And the reality is we wouldn't have a job if that were the case. So thank goodness that is not the case. But everyone is so specific, right? Whether their ownership, their voting, their control, their sale provisions, what their specific competition provisions and solicitation provisions, like you said, or specific details of their practice or how they want it to run or what's really important to them in terms of compensation or otherwise. These are things we can all include in the operating agreement. And like you said, it is tricky because we're often corporate counsel, right? So that means we represent the entity or the healthcare practice in this case. And we often put a provision in the agreement that says basically it discloses that conflict that we at Roetzel and Andrus, we're acting as company counsel and not counsel to any one person, not any one member or manager of the entity. And just to make it perfectly clear within the operating agreement that we are company counsel and not, and so there could be conflicts amongst members, managers, whatever. So we always put that within the body of the document to point people to that provision, even though we usually tell them as well, just to make it crystal clear that your interests may not always be aligned, especially if one has a greater ownership percentage, one has a greater equity distribution. There's different things that could change how it's handled, and we often disclose that. But I agree, there's different ways different lawyers like to do it. Conversations, checklists, all those things, but they're all very, very helpful. And I agree with you. The goal is to stimulate this conversation amongst the members of the entity itself.
Right. And I think the one thing to avoid is a lawyer who just has a form that they've always used and therefore it must work for you. And I feel like a lot of times our clients don't necessarily read or understand what's in the document unless you force them to. And so they just sign it thinking it's good because the lawyer recommended it, and then later when something happens, they don't find the terms to be reasonable. Also, if there is one person who's more the leader and went to their lawyer to help put it together for everyone, you do want to make sure maybe that you're having your own counsel review these documents just to make sure there's no surprises, which there are 100% of the time there always are. So I just want to be careful of that. So as we look through documents that might be used by a healthcare practice, let's talk about some of the key provisions that you like to focus on and talk through, with your clients. So take us through those.
So probably the key questions are, first, is everyone equal in their ownership, right? Are they equal in their equity distributions? So their percentage of profits and losses distributions, is that equal? Is it 50-50? Is it 70-30? That's one of the first things we usually ask. And then the voting and control, because those don't have to match. One of the beauty of the operating agreement is we have a ton of flexibility to create the agreement however the members decide they want it drafted. So maybe one member has greater control based on their ownership interest, or maybe based on that they just have greater control, or maybe there's a manager, maybe there's a day-to-day manager that gets to make a lot of decisions. But if there's a material decision like a sale or transfer of interest, then maybe the members also get a say. So those, for me, I usually think the transferability of the interests, obviously the ownership distributions and allocations, and voting and control, those are probably the first questions I like to start with. And then we kind of go from there. It usually leads to other conversations as to how they expect it to run, or specific terms that they want included. Like you said, that if they want to include a non-compete provision, a non-solicitation, we usually add a confidentiality provision that might be bigger or more robust depending on the type of business. If there's a lot of IP or other things that they're particularly concerned about, we might tailor it to the particular business that we're in, or to the particular healthcare practice, right? So that's where I usually start, and then we move on from there to the particulars.
Right. I would agree, absolutely. And I think, one thing people don't know about limited liability companies that's different than corporation is, you can share ownership profits in a different way than you can voting. And a lot of times people still keep it along the same lines because that was the intent. But that can definitely change over time. And that's one of the things that I think once our clients realize they really love about limited liability companies. Now, when we do these, we're usually doing PLLCs, so professional limited liability companies, for our doctor and dental practices. You need to check on the state law where you're sitting as you watch this, because some states have those and some don't. But typically they follow the basic limited liability company rules. It's just that the ownership, who can be an owner, typically has to be somebody who's licensed in the profession or a related profession. So you want to be very careful that you don't have your best, practice manager or your family member owning that interest. And that's one of the key things in professional limited liability company operating agreement that's going to be different from a regular operating agreement. So one thing to keep an eye on are those professional licensing type requirements that are going to be unique in your document. So if you're talking to a lawyer who does real estate LLCs and they're putting this one together for you, those are going to be a little bit different. Plus, just like an operating agreement, just like an employment agreement you might do for a dentist or a doctor, we a lot of times see those same things carried over to the operating agreement. So you're going to be kicked out if you lose your license or your DEA, your medical staff privileges, you're kicked out of a payor that's essential for the practice. So when we're thinking about these LLC agreements, in addition to what Jonna mentioned as being, key elements of an operating agreement, we also need to also sneak in some of those regular provisions where doctor can't be an owner of this practice anymore. That could also be impacted by things like disability, right? Because if you're so disabled that you can't hold your license anymore, then unlike, if you were a part of an LLC that owned a piece of property, you wouldn't be able to maintain your ownership in that practice anymore. So just an important thing to think about with these types of professional limited liability companies that might be a little bit different. So if you're owning both, a building with your partners and a practice with your partners, you can't just necessarily carbon copy them over. There's going to be some unique provisions to think about as well. And then I was talking to Jonna earlier, and I was mentioning that a lot of times what we like to do is include provisions like schedule, exclusivity, your actual clinical compensation approach might be in there as well, in addition to the profit sharing part of it, and things like that, supervision requirements, etc. What other types of things do you like to see in a limited liability company that's very specific to professionals? What do you come across, any unique provisions that are worth mentioning?
I think we touched on a lot of them. So like you're saying, those, and then the non-compete, the non-solicitation, the non-disparagement, compensation schedule are good. And like you said, these reps and kind of warranties, basically, that the physician or dentist is saying, I'm duly licensed, in good standing in the state. All those things we try to include within the document. But I think you hit on a number of the really important ones that I always try to include as well. But like you said, it's such a flexible document. You can include more than that as if you want as well. So certainly we can add more and tailor it to the specific practice's needs and wants and how they want to run. We can tailor it to whatever they decide, really.
Right. So let's talk about doctors or dentists that are joining a practice or leaving a practice, right? So one of the things you mentioned is that, this operating agreement would cover the transfer of an ownership. So if you have a bunch of doctors, one of the things you want to include is, how can a doctor be terminated? Can they give notice? Can they be terminated for cause, which would be some of the things I just mentioned, and what the vote would be for those kinds of things. But then when they go to leave, one of the key things would be, how do we buy them out, right? And so a lot of times what we like to do is include that formula. Is it a fair market valuation that's going to be performed? Is it a combination of a net book value based on assets plus some type of accounts receivable? There's no one way to do it. I think you would agree, right? We see so many different ways to do it. So how then should we prepare for somebody who is working in the practice but has not yet become a member? What does that look like?
If they're not a member of the practice yet, and they don't have an option to be a member, then we would just do a straight employment agreement. Is that what you mean? We wouldn't.
Yeah, exactly. And then what happens when we want to make them a member? What kind of documents do we need to do?
So then we would admit them to the operating agreement entity itself. We'd admit them as a member, and there's a number of documents that go to that. So we usually have an admission agreement, or maybe it's called a purchase agreement. We usually have them sign a joinder to the operating agreement, unless we really need to amend a lot of it. Then maybe we'd amend and restate the entire agreement. And then there's other things that come along with being an owner, which a lot of times when people are employees, they forget that you get the good and the bad when you're becoming an owner. So you might have to sign on to the bank loan or personal guarantees or the real estate lease. So there's liabilities and risk, as well as potential for gain, that comes with being a partner / member, that is different than just being an employee. So a lot of times in that employment agreement for maybe a first employee with the healthcare practice, it might have a provision that says they'll be considered for partner or member in an LLC within so many years. 2 to 3 years is what we typically see. But it's discretionary. It's not a guarantee of any membership in the future. Oftentimes the calculation for whatever that buy-in will be is determined later on, like you said, based on a number of values, depending on the practice. So it could be some combination of book and receivables. It could be fair market value. It could be appraised value. It could be all these different things. It could be determined by the accountant. It could be set. I've had practices that just say, this is the buy-in. And it's X amount of money with a promissory note over this amount of time. So really, we're flexible to do it however the practice really wants to structure it.
Right. Yeah, absolutely. And I usually see the formula for the buyout of members being kind of mirrored when we do a buy-in. So if you've done a really good job talking about what you want it to look like when you leave, then when you're ready to bring someone on board, we often can apply that same formula. And, so you're not recreating the wheel. We often will just kind of use that same approach. So one of the biggest issues that comes up, though, with operating agreements is when the partners get into a dispute. And hopefully we've done a good job drafting that operating agreement. The things they might be fighting about would be the compensation formula. But if it's written properly, it should be spelled out properly, how expenses are handled, how decision making is handled. So a good operating agreement, hopefully these disputes are avoided. But sometimes we get in a situation where, let's say there's an equal number of owners and it requires a unanimous vote on something, right? Or somebody's doing something that they feel, hurts the practice, and it's maybe not, clear as to how that's to be handled. What do you like to recommend in terms of language on handling disputes? And I think the worst situation is not to discuss or propose any kind of solution and just say, oh, we'll figure it out when the time comes. What is the best approach you've seen or actually had to apply?
Yeah, I mean, I think you and I, we often put like a deadlock provision within the agreement itself. So if you get into this situation where if it was a unanimous requirement, you can't get unanimity, or if it's, majority, you just can't, if there's two partners and you can't agree, we put in a deadlock provision. They're not always perfect, but at least they create a process by which to at least attempt to resolve it amicably. So usually we require the partners to get together with, separately for some period of time, maybe with outside counsel, maybe with accountants, and attempt first to resolve it amicably. If that doesn't work, maybe they go to arbitration or mediation. And then last resort would always be litigation. Always. But I
Right.
mean, it's just so expensive and so harmful to everyone that would always be a last resort. I think you would agree.
Right. Yeah, no, I see those very commonly. I've seen some interesting ones lately. One I saw was that, if there's two partners or even more than two partners, that if there was a kind of a deadlock, that they each like rotated year for year, having the right to have that
Oh, that's interesting. Yeah.
deadlock breaking decision right,
Oh, that's a
right?
good idea.
Or like maybe each one got 2 years at a time. I've seen ones where if there were two members, let's say, and they absolutely were to deadlock, one of them could say, all right, I don't agree, either buy me out or I'll buy you out, something like that. So, I mean, there are a lot of those are kind of drastic solutions. And I think that should come at the end of an effort to bring in, maybe your accountant. The accountant is usually a really good resource for sitting down and talking, or something like that. But people are really kind of getting creative. The last thing you want is to go to court. It is so expensive, and just you can never repair your relationship
No, you
after
can't.
that. So you might as well just think about selling at that point if you've gotten to that point, right? And I think, one of the points I was trying to make early on that I'll make again is that if you have someone either with more experience or a stronger personality, they tend to want to use their lawyer and their accountant, et cetera. And while it's very flattering because I've been their lawyer before, it's not always in the best interest of the practice. And I think, as lawyers, we need to always say either let's make sure you have your own lawyer so we can make this a fair process, or, let's make sure there's no conflict here. Because at the end of the day, really, as lawyers, we're put on the hot seat as well if the language is not either fair and neutral or documented as to why those decisions were made, which is why I like kind of that checklist process where we could say, look, you guys sent us your email together with your notes on it. That's why it was done this way. So, very often I find myself in the situation where, the main person may not own more, but maybe they were the one that hired the lawyer and the accountant, and it's also their personal lawyer and their personal accountant. And when things start to fall apart, it just is a disaster. I don't know if you've had that experience as well, but it can be very sad in terms of the outcome of those situations.
Yeah, I have had that situation, and I kind of lean back to that conflict that you brought up earlier, that we're often company counsel, right? So if there's a significant dispute and between the members, right? Sometimes I use that interchangeably, but I mean members in this situation. Right. And if there is that kind of dispute, I've had the situation where I've had to advise them to get separate counsel, that I could tell, even though I'm functioning as company counsel and trying to be a neutral party, doing what's in the best interest of the company, invariably one party feels like that favors one more than the other. And so in that case, I have had this situation, and it's certainly not fun. It's tense, but it's better than going to court. So they have their own lawyers then, and I act as company counsel, and we tried to together come to a mutual understanding and resolution of whatever the problem is.
Right. Absolutely, I agree. I have had to step aside many times. And, as a lawyer, it's sometimes a relief. It's very hard
Yeah.
to kind of balance everybody's interest, to be kind to everyone, especially because usually there's at least one of those members that are being unreasonable.
Yeah,
And
right.
you can't call them out and tell them, stop being a jerk. You're really,
Mhm.
you're the one that's being
Yeah.
unreasonable. So you really just have to step aside. Now, I'll reiterate again that, it always helps to have a really good understanding from the start and to have the document reflecting how the parties wanted things to be. But we can't predict every situation that's going to occur. So these things can happen. Dispute resolution provisions are really great. Making sure, you were properly represented when you did it is great as well. But if these events do occur, I think it's always great to be able to look in the document and say, this is how we said we wanted things to be handled. So that's always
Yeah.
the goal, right?
I completely agree. And I think one of the benefits, while we don't have this magic form that works for every situation, experienced counsel like yourself and hopefully myself have done enough of these that we have many, many different versions. We're not reinventing the wheel from scratch, right? We have different agreements that are very good in different situations. They're not perfect and they're not a perfect form for any situation, but a lot of them we've dealt with these situations before. They've been negotiated or we realized where the failings were. Like a dispute came up that we never imagined, and now it's kind of what we include, even though maybe it's not in a typical operating agreement, because we've seen it, more than once, and it's not this aberration. Then we're like, we should put in this provision going forward to kind of help these people. And I will say also, which I'm sure you've had the case, that if the partnership is all smooth sailing and there's never a dispute, they almost will never look at this agreement. That's wonderful if that's the case. It's
Right.
when there's a problem that arises, then every minutia of this document is going to be analyzed, and all the things that they wanted to brush over and go quickly and like, oh, I don't care about that's legalese, or I'm not interested in that provision. All of a sudden, everything becomes a big, big issue if there is any, source of contention between the members.
Absolutely agree. Well, I hope everyone has found this helpful. We could probably talk about this topic forever. The idea would be, if you need an operating agreement, if you should have one, but you don't, if you're not sure the last time you looked at it, if it has these types of provisions in it that we've talked about, feel free to reach out to Jonna or myself. We're happy to talk you through it and to answer any questions that you may have. Thanks for joining me, Jonna. And
Thanks for having me.
Thanks to all of you for watching us on the Health Law Hotspot. We hope you'll join us next time, and you can check out some of our other podcasts at ralaw.com. Thanks so much for joining us.
The Roetzel Health Law Hotspot is made available by the firm and its attorneys for educational purposes and to provide general information, not to provide specific legal advice. Use of the Roetzel Health Law Hotspot does not create an attorney-client relationship between you and the firm or any of its attorneys. The Roetzel Health Law Hotspot should not be used as a substitute for competent legal advice, and you should contact an attorney in your state about any legal needs or questions you may have.